Hello, everyone. I have an update on a Carmelo Anthony case. Some of y'all may have seen earlier where I said that Judge Cockroach has recused himself, which is partly what happened today. However, it's a little bit more. With that being said, shout out to the Fit Lawyer. Shout out to the Fit Lawyer ATL. Let's get it.
Afternoon, everyone. I am live here in Collin County, McKinney, Texas. I was here in town today for the Karmelo Anthony hearings, and I'll be here tomorrow. So come on into the room, and we're going to give you a play-by-play update of the motion to recuse. Shout out to Happily Angry Lawyer who is in the house. Shout out, partner. We are working together on the Antonio Sledge appeal. Yes, it's still pending. Yes, stuff is still going on, which is even more testament to you put your best foot forward on the first time your case goes out, because it is very hard to pull yourself out of a hole. So shout out to Happily Angry Lawyer out in California. He's also a YouTuber, so follow his channel. I think he's going to be covering stuff about Dirt tomorrow. I think that trial starts tomorrow. He's been doing some coverage on that trial, so check him out. As you come into the room, like, share, and subscribe to the channel. My name is the Fit Lawyer ATL. I am a 20-year criminal defense and personal injury attorney here in Atlanta. I'm out of town today, but in Atlanta, Georgia. I have my own practice. That's theadamsfirm.com. If you ever need an attorney for a criminal case in Georgia or a slip and fall or car accident, give us a call, 404-507-2889. All right, so as you come into the room, be sure you like, share, and subscribe. Because Fit was in town today. I came into town last night into Collin County. I am staying in McKinney, Texas, down the street from the courthouse. And I was there today for the motion to recuse Judge Roach. And there was like a gambling thing or anything I could put money on, it was going to be that hearing. Like, that was kind of an easy hearing today. I think I was back in the parking lot reporting live at 10:42 Central Standard Time, and court started at 9. So that is how quick that hearing was today. Tomorrow is going to be a totally different story. So make sure you like, share, and subscribe, and I'll keep you all updated, because tomorrow is going down. I heard words from someone who talked to the appeals attorneys. There are going to be some witnesses testifying. Tomorrow is going to be knock out, drag out. All right, so let's see who else is coming into the room. Try Hard HG4498 says, thank you so much for tuning in, sis. Brooks Christian says, hit the like button, everyone. Debbie Jenkins 7840 sends a whole bunch of, thank you for the green hearts and a whole bunch of purple hearts. Purple was the color that the Karmelo Anthony supporters were asked to wear today, so there were a lot of people in purple, fuchsia, and everything. Redberry Diva C031 says, hello, just got through looking at morning coverage. Glad you're there. Thank you so much. Thanks for tuning in. Yeah, this morning, so we don't get into everything play by play, but I wasn't able to take my phone in, right? So I had to do a quick video. I don't even know if the sun was up when I posted it, because we were let inside at 7 a.m. and I didn't get back to my phone until after the hearing. So it seemed like things were happening for a long time, but we didn't get into the actual courtroom until 9 a.m. So come into the room, hit the like button, share, and subscribe. This is Khadijah 2748 says, you know, Tupac trial on, but free Carmelo. Yeah, it sure is. Yeah, stop over here for a little bit, get this update, go back, or you can come back later over here, because this will be available. All right, shout out to Miss Candy, Fit with the boots on the ground journalism. Yes, ma'am, in person. Actually sat behind Jeff Metcalf today in court. I was a little to the left of him, so I was able to see all his facial expressions the entire hearing. So that was quite interesting. Just say Jaylyn 8264 says, hey Fit, you were doing your thing or thing. I am so proud of you. Thank you so much. If you all know, I started my channel during the YSL trial, being nosy, being boots on the ground at the courthouse, giving some tea in the chat on the lead attorney's channel, and it is grown from there. So we are covering also the big ticket, so make sure you stay around for that. I will be back in the courtroom tomorrow. Let me see a couple more comments, and then we're going to get into it. Brooks Christian says, if appeal is granted, is it possible to get a bond hearing at that point? So yes, if he is granted a new trial, that means his case goes back to the beginning. He actually returns to the state he was in prior to being convicted, which is on bond. So I believe it'll kind of be an automatic thing if the motion for new trial is granted. I believe it should work right because, if you overturn someone's conviction, they go back to the state they were in before they were convicted, and that was on bond for Karmelo. So I believe that is how it worked. It should work. Perspective Me says, so Sylvia, if you're talking about the YouTuber, yes, I am aware of her, and I was actually, because you said Sylvia, I'm thinking about Dennis, right? So I actually went up on Dennis Byron's live earlier today and gave a little breakdown there. So shout out. Sheila McCoy 135 says, you're the best lawyer. Love you, Miss Sheila. Thank you so much for that shout out. All right, so let me get into it. So I flew into town Tuesday afternoon, and if you've been following the channel, I started covering the Karmelo Anthony case the day the verdict came down. So we got on stream, waited for this verdict, and I was surprised it came so quickly. And then sentencing came quickly, and then everybody was just stunned. So I started covering it then. And over here it's about the facts, right? So I actually broke down why I believe the jury got it right. Not because I'm saying I agree, but it was based on what they had, right? Because the jury can only make a decision on what evidence they're given. And at that time, we had so many questions like, why wasn't a defense put forth? Why didn't Karmelo testify? Of course the jury's going to decide this because they weren't given anything else. And then the motion for new trial was filed. That was filed July 7th. And they had 30 days to file that motion, and along with that came the motion to recuse, which was heard today. All right, and so we'll get into what's going to happen tomorrow. That's going to be the motion for new trial, but today was the motion to recuse. So as you come into the room, make sure you hit the like button, share, and subscribe. And all right, let's get into it. So court started at 9 today, and since I was in the bushes on a lot of YouTubers' channels, I had already heard that during the trial, they were having to arrive about 6 a.m. to make sure they got inside of the courtroom, okay? So that's what time I got here today. Luckily, I did, and when I drove into the parking lot, I actually parked near Nika Knight, who is another YouTuber. If any mods in the chat, please drop her channel.
If you have tried multiple oral antidepressants and
her channel, and she has security with her. And as I got out of the vehicle to kind of go towards the crowd, I saw the steps to figure out what was going on. He was like, do you have a card? I'm like, no, what are you talking about? What card? And he's like, you need to go get a card from the sheriff so you can get inside the courtroom. They're only letting in 40 people. So I'm like, okay, good. Let me run over to the sheriff. Got my card, number 37. Okay, so I almost didn't make it inside the courtroom, but I did. So shout out to Nika Knight. Thank you so much for your security. I really appreciate that tip. So I got my card. And at that point, you're just told to make sure you're back at the top of the steps in line by 7. Okay, so I had some free time to run a couple of errands. I got to set up my tripod and do like a quick little video outside of the courthouse. But we had to just be back in line at 7. So at 7 o'clock, or close to 7, a lot of people started coming up. Now, we had to leave all electronics in the car. Smart watches, no fans. I know it's hot. So some people were sitting in the car until right before 7 because it was already hot this morning. Just everything you had to take off electronically. Leave it all in the car, so no phones or anything unless you were media. Some certain media could bring in not cameras, but they could bring in like laptops or their cell phones to type and send information into their channels. But if you were just public, you couldn't bring any electronics. That's only for the Karmelo Anthony hearing. So this is a big courthouse, right? So there are other hearings that are going on at the same time. So at security, there was a sign that said, no electronics for Karmelo Anthony, for the Anthony hearing. So that we were the only ones stripped of everything, not everybody that entered the courthouse, because it's not a federal courthouse, so you can bring your phone in, just not for the hearings. So we come in at 7. It takes, I guess, maybe like 15, 20 minutes for all 40 people to get through security. If you were not one of the 40, they immediately started lining you up off to the side of the front door for the overflow room. So they came in shortly behind us for security so they could have time to check everyone in. I am not from Texas. I am from Atlanta. It's the Fit Lawyer ATL. And so I don't know who Pastor Haynes is, but if you're from Texas, Pastor Haynes brought a whole bus of people here to support Karmelo Anthony. So a lot of them were in the, I'm sorry, I'm twisting the turn like a little kid, were in the overflow room. So they were in the line that was kind of off to the side this morning and all came inside. So people from Texas that I was in line with to go inside the courtroom were familiar. So they're like, oh, it's Pastor Haynes, it's Pastor Haynes. I saw him hugging people, but I don't know who that is. But he's a prominent pastor here in Texas. So he did bring a busload of people to support. Dominique Alexander, if you all have been following this case, who was the public's first representative, he was there. He came in, not with the family. I would say he came in after we were already lined up to start walking inside. So I think it may have been around like 8.
And the way I hear it, when it comes to Dominique Alexander, the family don't fuck with Dominique Alexander. They ain't been fucking with Dominique since like months before the first trial. They don't even fuck with that man.
40 or so, he came in and he did hug some people. I mean, it appeared as if he was still working with the family, only because, like, why are you here hugging people, coming through the hallway, all of this if you aren't? So I don't know that logistically, but he was present. I think he had about 4 or 5 people flanking him. We did not see Carmelo's parents come in because we were kind of just sitting and talking in the hallway that they placed us in, but people started whispering, like, I think they flew by us, so we didn't see them come in. But of course, we saw them as they started going into the courtroom. So the first people to go into the courtroom would say about 8:30, they started letting media in. So they let them in. After the media went in, the dream team, as everyone affectionately calls them, the appeals team for Karmelo Anthony, that's led by Russell Wilson, they came in at 8:35. So they came in, there were cheers, claps from people in the hallway, the supporters of Karmelo Anthony, just, supporting them. So there was a loud round of applause as they entered the courtroom. That was about 8:35. After that, then I would say that they started lining the 40 up that were from the public that were going to go into the courtroom, and then the families came in. So the Metcalf family came in, and then Karmelo Anthony's family came into the courtroom, and then we were allowed to come in. So I was number 37, so I was in the last 5 that they let in to the courtroom for the public, and got the last seat. So I sat on the 3rd row on the left side of the courtroom, all the way against the wall, because I wanted to be able to have that angle to be able to see everybody, and I could see, like I say, Jeff Metcalf's face, because I probably sat behind and 2 people over from him, and his wife, ex-wife, was 2 people over from him. So they were on that 2nd row on the left side. The first row, I think, were people who were with the DA's office or court staff personnel. Karmelo Anthony's family was on the first 2 rows of the right side. His parents sat on the edge. And then, of course, Karmelo was present. I'm not sure why a lot of people online were thinking that he wasn't going to be here, but the defendant has a constitutional right to be present at hearings, so he definitely was here and brought out. He came out in a green prison jumpsuit. They don't dress criminal defendants out into suits unless they're going to be in front of the jury. So anytime that they're in custody and the jury's not going to be there, they're just going to be in their prison blues, is what people sometimes say. In this case, it was a dark, forest green colored jumpsuit. If you all remember the last picture I think we saw of him was when he was taken to the Department of Corrections for Texas, and they shaved his head, which is what they kind of do in every state. His hair is grown back. Afro or anything like that yet, but it's definitely not anywhere near bald, and not like a low cut Caesar. It's a little thicker than that. When he came in, I was like, oh my God, he looks so small. He looks so small. I remember when the trial occurred, I think they were saying Karmelo was maybe 150, I think 140 or 150. He is skinny, so he looks skinny now. I don't know if he's lost weight. I can only imagine that, he would have lost a little bit, or if this was just his normal stature, because we've seen him, I've just seen pictures or sketches. So to see him in person, he's very little. And when he came in, they set him at the table. He's handcuffed in the front, and his attorneys are around him talking, and he's just kind of looking up, like looking around, trying to, be a part and see what's going on. And you can tell. I mean, he's not a lawyer, right? So he doesn't understand every little thing, but he was very into whatever the discussion was and trying to keep up with what was going on. So this is kind of setting the scene right before the hearing started. So let me go to the questions and see if you all have any. Let's see. Yes, like, share, and subscribe, and hype the video. Shout out to Big Shot Ammo. Thank you so much for that comment. Okay, we talked about the bond part, and my thinking is that, if a motion for a new trial is granted tomorrow, the defendant returns to where he was at the time that he was convicted and he was on bond at that point, so he will return to that position. Khadijah 2748 says 30 joules. Thank you so much. Shout out for you. Thank you. Yes, we're going to get into this gentleman's agreement. That is going to come up tomorrow on this motion for new trial. That is their second point. Let's see. I would say he came in just kind of looking a little nervous. It's not trial, right? So you already are sentenced. So this hearing can't get you. You're not going to be in a worse position than when you walked in. But just kind of, nervous, a little shy, a little bit. He doesn't really know what's going on. I will say he didn't come in. Sometimes defendants come in that are kind of used to this, and they'll come in. They instantly look, scan the room, look for their family, start shaking, shaking their head, nod at family, mouthing words. He didn't do any of that. He didn't look back at his family. He just came straight in. And sat down, did his told, and faced forward. He's young, so he's obedient to what he's being told to do.
Chamberlain University has led the way for those called to care. And now, for RNs ready to earn their advanced degree, Chamberlain is offering savings up to $11,000, our biggest commitment yet. Chamberlain University belongs to something greater.
My name is Candace DeLong. I was an FBI agent for 20 years. I specialize in profiling and tracking violent offenders and serial killers.
Okay, so, we're going to get into this. Big Shot Ammo has a great question. He says, how does the judge who grants a recusal while also trying to say there was no violation of judicial canons? Is it because they're colleagues, that judicial bias, perhaps? I'm going to start that comment and come back. So y'all just hold on to that. I'm going to come back and talk about that. All right, so let's get into it. So that's the scene before it starts. I thought that this was going to be streamed, but it actually was just streamed to an overflow room through a Zoom app. So that is how they did that. So they set up everything, got the overflow room going, and then brought the judge out. Court started right at 9. Like I said, it was the last 5 of the public to come in. And so I feel like 30 seconds, maybe a minute after I sat down, court started. Like, it wasn't a delay. Court started. So Judge Sid Harrell was appointed by the administrative judge here to handle this case. So a motion to recuse was filed along with the motion for new trial. Once that happens, the judge who was filed against, which was Judge Roach, he has to review it. He has to review that motion and ensure that all the legal requirements of the motion are there. Was it filed timely? Yes. Was it filed, did it raise a question of a bias? Can someone reading this who is, not a party to this case, look at all the facts and decide that there's a bias here? If there's a possibility of that, then it has to be either the judge has 2 options. He can then recuse himself. Judge Roach did have the ability to skip all this hearing stuff and just simply recuse himself. I mean, he's retiring at the end of the year. So what, right? Just recuse yourself. But he didn't. The second option, and this is what he did, he sends it to an administrative judge. That judge then assigns another judge to hear the recusal motion. What the administrative judge did in this case, which was great, because sometimes, there's a recusal motion that just came out. Actually, the DA in DeKalb County in Georgia filed a recusal motion of a judge there to have her recused off of all of her pending felony cases before her. And so she read that motion, did not recuse herself, but referred it to a chief judge who then assigned it to another judge that was still on the bench with that same judge. So of course, it wasn't granted. But here, to remove all question of bias, the administrative judge appointed a judge that was hours away. So Judge Sid Harrell is from Bexar County. We are in Collin County, Texas. Bexar County is in San Antonio. I'm from Georgia, okay? 4 hours to get you out of the state. In Texas, you're still in Texas and you're still not where you trying to go. Okay, Texas is huge. So San Antonio is far from where we are in Collin, Texas, and that is where this judge came from. He even spoke about not knowing Judge Roach at all. He says he probably seen him at a judicial conference, but they're so far away in that they don't intersect, so they don't know each other. But they're still judges, and so you'll talk about, and that was the question I just started. You're going to kind of see how, even though he didn't know him, he still tried to make his ruling today. All right, so Judge Sid Harrell from Bexar County, he actually deals with, let me go to his website. Let me not mess this up, because I pulled up his profile so I could be able to kind of tell you all. So he's a judge over the administrative judicial region. So he covers things, making sure judges follow the law, making sure they follow the judicial canons. Like, he's over that division that sits over the judges. So great person to bring in, right? Because you're going to know kind of what somebody needs to be recused for. So great decision to bring him in, and he made the right call. All right, so he comes out right at 9 and calls the case, meaning he puts the name of the case on the record. This is State of Georgia versus Karmelo Anthony. We are here on the defendant's motion to recuse filed in conjunction with the motion for new trial. All right, so that's putting it on the record and get started. So it's the defense's motion, so the defense will go first. So Russell Wilson spoke today for the defense. A couple of the other defense attorneys introduced themselves, but he is the person who was running this hearing. And so he tells the judge that the state and him have already talked about the exhibits that they were filing with this motion. So I don't have a copy of those exhibits. They weren't filed previously with the motion, but they were filed today in court and referenced, and they had already talked about them, so they were going to be admitted. So it wasn't a discussion about them. There was exhibits 1 through 12 and 16. I think there was some misnumbering, so that's why it's 12 and 16. And so what I gathered after hearing the hearing, that a lot of the exhibits were simply, of course, the video. That was the only evidence that was entered, Judge Roach's interview that he gave on the news channel, and then a lot of ethical opinions that the Texas Supreme Court has issued on different matters that they felt relevant to the hearing, as well as the judicial canons that the judges are supposed to follow. So that's what I gathered that a lot of the exhibits were. So I did pull up one of those just so I can give you an example. We're not going to go through all of the opinions referenced, but I do have the numbers if you want to look them up on your own. All right, so Bill Worski was speaking for the state, and he said, yes, Judge, we already talked about the exhibits. They're admitted. We don't have any issues. So exhibits admitted, so they didn't have to stop during the hearing to do it. They didn't have to say, where did this exhibit come from? Is this a true and accurate representation? They didn't have to go through all of that. They talked about it. They stipulated it, so the exhibits were admitted. And then one of Karmelo's attorneys then asked if he could be unhandcuffed for the hearing. The judge was like, oh, well, I don't run the courtroom. That's up to the deputies, so they can decide. He didn't have an opinion of it, and the deputy that was close by started walking up to Karmelo and was like, all right, Judge, well, I don't care either. So the deputy was looking for the judge to make the decision. So they uncuffed Karmelo while he was at the table for the hearing, and he was just able to freely move his hands and participate with his attorneys during the hearing. So after that, the judge says, the defense, this is your motion, you get to go first. So Russell Wilson stood up. He said, thank the judge for coming from afar to hear this case. He once again talked about the exhibits that they entered and said that they wanted to publish the video, and that after they published the video, which was 18 minutes long, that they'd be resting on evidence, meaning that they would be done with their evidence presentation, and then they would have legal argument, and that was it. So the only evidence in this case was the judge's interview that he gave 2 days after the verdict. The defense then stands up and just says, Judge, at the defense, the state stood up and said, Judge, you read the transcript of the interview. I don't really see the need for it to be published. And then Judge said, well, yeah, I did read the transcript, but if they want to publish it, they can. It's their motion. And it kind of was like it needed to be, because had it not been published and we just rested on the judge's transcript, the hearing would have been done then, because the judge kind of felt like he already knew what he had to do. It's really clear. I'm not sure if if you all have heard this interview. I'm going to just quickly share. I just want you all to see the setting that this interview occurred in, and because some people are new here and just tuning in to what's going on with Karmelo Anthony. So let me bring that up. Just share with you all. Oh, interesting. Yeah. Hold on. I'm trying to see. Oh, here it is. Alright. Okay. Alright, so this
John Roach. JOHNROACH.
Cockroach.
I know the answers. I know the answer to that question, but I got to ask it for the record.
100% now.
You've been on the bench for some time.
Yeah, I've been on the bench for about 20 years.
20 years, and this is the end.
In that 6 months, it'll be in the end.
Did you want to take on this trial?
What happened? Huh? What happened?
There's power in the word no. At University of Phoenix, there's no application fee, entrance exam, or obligation to enroll. We'll even request your transcripts at no additional charge when possible. We believe higher education is for anyone, so we're making it accessible for everyone. Discover the power of no at University of Phoenix.
For the first time in history, we are living in a society with 7 different generations.
So that's the interview. So you see the setting. He's actually in the well of a courtroom, and he's being interviewed by a news station here. So they take him through several things in this interview. I've heard it several times, but I took some notes today because I wanted to write down things that I knew would be relevant to the motion to recuse. Let's see if y'all have any questions. Shout out to Lisa J. Snipes. Thank you. She sends 30 jewels. Thank you so much, sis. I saw your comment wishing me safe travels. Thank you so much for that. Thank you so much for being here. Let's see. Alrighty. Just trying to see if y'all have any questions. Someone says, is there a chance Karmelo can end up with more time because of this? Yes. It's just flat out, right? If he gets granted a motion of a new trial and goes to a new trial and is found guilty and the jury decides to give him more time, then that would have been what occurred. All right, so that whole interview is played. It's 18 minutes long, and I'm just going to point out some things that are in there. He talks about being on the bench for 20 years and how he's getting ready to retire in December. And so they asked him, like, how did you feel when you got appointed this case? Because you don't get to go to a court and say, I want Judge Roach, or I want Judge Harrell, or I know Judge Cox. We got a Judge Cox in Fools. I know he's easy on this. I want Judge Cox for this case. You don't get to do that. There's like just imagine it's a wheel, a spinning lottery that's turned. That's a wheel that's turned. And so it's just a random selection of the judge when a case comes in. And so you don't know who it's going to be. So while he wasn't asked, like tapped on his shoulder, like, will you be the one? But he came up for the one to be assigned to it. And like he says duty is a big thing to him. He was in the Marine Corps. He takes duty to the Marines, duty to his family. He takes duty very seriously. So he was happy to be assigned the case because that's his duty to be a judge. And so he was happy to get it. He talks about how he worked with the Collin County services, the clerk's office, the sheriff's office, the police department, the who else? Just different agencies, other close counties, Frisco County, to coordinate this trial because it's going to be the biggest thing that's happened here. And so it was really, really big because of the social media attention, right? There were so many people covering it. I mean, a lot of us in the 40 of us that were coming to the public were content creators. They're YouTubers, TikTokers that were there. So this thing really, really got big on social media. So he knew that it would be a really big deal. And so security was an issue. So it was about working with the police and how are we going to secure things. So they prepped for 8 months to prepare for this trial. So he talks about that. They talked to him about, why did he close the courtroom? And he said, well, they asked, was it because minors are testifying? He's like, well, minors testify all the time in cases. You got to know, like, this is not the first time kids have testified in a criminal case. You have child molestation cases all the time with kids, sex trafficking cases with kids, murder cases where kids are witnesses, right? So this is not the first time that kids have had to testify. So this is not a unique situation in that point. And he spoke to that in the interview. And he even said, one big thing he said in the interview was maybe I should have had an audio feed of this trial, right? Maybe then it wouldn't be so many questions about what really was said because, there were people that were putting out fake information or false information about what was occurring at trial, and just so many people wanted to see. So when we were kept out, it leaves people room to make up things that occur, or they feel like justice wasn't served because they didn't get to see it. And so he thought he said that in the interview. Maybe I should have put an audio feed. And then he comes back and said, oh, well, people would have still distorted what they heard there, but we're going to come back and why that statement is so important, and it came up in the motion to recuse, and we're going to hear that statement again tomorrow in the motion for new trial.
Okay.
They asked him, did the jury get it right? And he says yes. And that was a big part that Russell Wilson argued. What did that yes mean, right? He says, yeah, the jury got it right. They were in panel, they deliberated, and they came back with a verdict. All right. And so when the state argued, they say that statement is just an explanation, just saying the jury got it right because their job is to get a verdict. And so they listened to the evidence, they deliberated, they returned the verdict. That's all I meant. But Russell Wilson's like, no, I mean, is that what it meant? Who knows? That could have been what it meant, but you could also meant that you agreed with the jury verdict, and that's the issue, right? Because you're the judge on the case. Still, there are appeals issues that could come back before you after the case, and you're making these statements 2 days after. Like, I've been practicing now for 20 years, and I have not had a case in 20 years where a judge has made a public statement in. So we usually see that in a documentary after people have died off, after the defendants got out of jail, like years later, where there's no more appeals that could be heard, right? You don't see a judge do an interview 2 days after the verdict comes down. On a case this big,
There's DNA. There's heavy DNA.
the verdict comes down on a case this big, and an appeal has already been filed. So really weird. As I stated, also in the interview, he says that he even talked about social media and how he didn't let it impact him. And then, remember when people kept saying, and there were pictures coming out that with him and Jeff Metcalf, he speaks about that in an interview saying, no, I didn't know them. People can make up AI stuff and you just don't know what to believe. He felt like he was doing a good balance between the media and the public. The interviewer asked him that, he said he had 200 requests from media and only 70 seats. So he had to kind of balance it all because you want to get the family in. You got to get the family on both sides in. You got to get court staff in. You got to get the public in, and you got to get the media in. So he says, I had 200 media requests. Well, I can't let them all in, and then nobody from the public would be there. And the interviewer says, well, isn't the media an extension of the public, right? This wasn't going to be streamed to the public, so the media being here are reporting it back to everyone else. So why would you keep any of them out? And so that kind of gives rise to the argument for tomorrow about the restrictions. He just, you get from it, and I've always said this, he really feels like he did everything correctly. He says, I followed the law so I can sleep at night. I did everything by the book. I did everything by the law, so I did everything right, is what he said about himself as well. They also asked him about Karmelo in the interview, and he said that he didn't know him outside of this case, but he had occasion to speak to him a few times because he has to, tell him his rights and all that stuff. and he stated that he seemed to be a good kid, but that made a mistake, and he knows now more than ever the consequences of his actions. So then you're speaking there to the defendant's guilt. So you spoke about the jury getting it right. You talk about the defendant's guilt in this case, and so that is what led to Karmelo's defense team filing a motion to recuse, because the motion for new trial.
When you guys go to date, do you guys want a traditional man?
Yes.
That was not so. Dang it.
Is what led to Karmelo's defense team filing a motion to recuse, because the motion for new trial is usually heard by the trial judge. That's why they're usually never granted. Because what judge 30 days after he just sat through a trial and feels that everything was done correctly will be able to come back and hear that, oh, something wasn't done correctly and grant? Motion for new trials are usually never granted, okay? However, in this case, they got the judge off. So tomorrow is not going to be the trial judge hearing his errors. It's going to be a fresh judge. Now, this judge has had some. He's been overturned as well in the past, right before he got retired. But I think that may be a good thing, because I think he won't. Judges don't like to be overturned, okay? They don't like to be in Westlaw. They don't like to be in the books for saying they got something wrong. So I think this will be a good thing on this case, and that the judge will really, really be careful and really make sure that he follows the law wherever that leads us, okay? Because we've only seen the defense's motion for new trial. The state did not file a response. They will simply argue it. All right, so once the interview ends, it's 18 minutes, then the defense says, Judge, we rest. The judge asks the state. The state's like, nope, we don't have any evidence, we rest. Just got argument. So then they move to the argument section. And it's kind of a pause before we get started on the argument section. And I'm going to pause here and see if there are any questions. Shout out to Teresa Wright 828. Thank you. She became a new member of the channel. Shout out, sis. Thank you so much. Dialogue with Me TV says you were looking good out there, fit lawyer. Thank you for having boots on the ground. Thank you so much, because y'all, it was hot. I had to come back and watch it, because I was like, do I look like I'm melting? Because it was like 106 when we came out of the courthouse today. So Mr. Big Play Bray says, damn, more time on the table. How would you handle that if it was your client? This was my client. We wouldn't have made it to trial, okay? This would have been something that everything would have been handled differently from day one. However, in this case, I mean, look, this is what happens, because everybody just assumes that if he gets a new trial, it's going to be the same trial. It's not. It's going to be a very different trial. What was kept out of this trial, and we're going to get into that, and we'll talk about it some more after the motion for new trial, there was this gentleman's agreement. In this agreement, both sides are made an agreement to keep out the bad stuff about their clients. So the state kept out stuff about Karmelo, and the defense didn't bring up bad stuff about Austin and Hunter. So there existed negatives on both sides of this case. You try this case again, everything is coming in, baby. I don't know what all this stuff is, but it's going to be a new case. They're going to, first off, they have to get jurors that are unaware of everything. So this is not a case where the same jurors get to come back and you get to run it back. No, the jurors that will sit for this case will not know anything about this case. They will be open and they will be unbiased. They will get presented the evidence in a new way. They will get presented all of the evidence, if it goes to a trial. They will get all of the evidence presented about Austin, about Hunter, about their arrest for tagging racist graffiti, about them being bullies, allegedly, about an email that the cheerleader sent about them bullying them. If you're an unbiased juror who you haven't kept up with anything, so you don't know anything about the first trial, you're presented facts of that. You're said, okay, wait a minute, it's paint a different picture, and then Karmelo gets to testify. So it's not going to be the same trial. So it's not going to be a repeat. It's going to be differently. So it's going to be different. So it could be a different outcome, but it could be the same outcome. And for murder in Texas, it is 1 to 99. So he could get up to 99 years. So if the jury in that case hears it and feels differently, and whatever this extrinsic evidence of Karmelo's that they kept out comes in and it sways the jury, he can end up with more time, or he can end up with negligent homicide. That was something that didn't even come up this time, right? Because the evidence didn't allow it, because they didn't really get to present a defense because of the breakdown of this agreement. So if he gets granted a new trial, it's not going to be the same trial. Things will be totally different. So it could lend to a totally different outcome. Let's see. Any more questions? Okay, so White Jodeci 8926 says the entire motion doesn't make sense to me. The jury found him guilty and set the sentence. Stay tuned because I'm gonna make it make sense to you before you end this live. All right. So let me finish going through. And again, now y'all, this is just a motion to recuse Judge Roach. That's what was today. But I'll get into the points for the motion for new trial tomorrow shortly. All right. So they're at the argument section. And so now the defense goes first again because it's their motion. Russell Wilson is trying to play a PowerPoint presentation. There's some issues, AV issues. They get the tech guy in and then it works. So it's like maybe about 10-minute delay, maybe 5-minute delay, if that long, before we start the argument section. All right, so a big PowerPoint pops up, and at the top of it, it says, the court's own public words. What would a reasonably and fully informed observer think? That's the first slide, okay? And they're right? Because they literally use the court's own words. This wasn't a recusal motion where you have to present a situation and you want someone to infer bias. Like, you literally, we are taking the words out of the judge's mouth. And this isn't about the judge being biased during the trial. Absolutely not. There was no argument or anything that came out that he was biased at the trial. It simply was the interview 2 days later when there are other legal proceedings that will come back before you. So you weren't biased during the trial. Nobody has made that argument. But when you did the interview 2 days later, now you're biased. And now my motion for new trial that I have to file within 30 days of my conviction, that's going to come back before the trial court, you don't need to hear because you've shown us that now you have a bias. So that is the only reason this motion to recuse was filed. If he had never done an interview 2 days after, I don't believe a motion to recuse would have been filed at all because there would have been nothing that he did that showed a bias. So just be clear, this is only about the interview 2 days after. The next slide talks about canons. It starts going through the judicial canons, and I have that pulled up. And the judicial 3B10 is where they started. And the judicial canons are like bar rules for attorneys. They are rules that govern how judges are supposed to behave. And let me go to those. Everything I'm pulling up, you can simply Google and pull up and verify yourself. And I just want to, that's why I'm going to share the source screen from things so you all can see, like, we're not making things up here. Let's see. Some tabs, trying to find that. Right tab. 1 second. Oh, you know what? Sorry, guys. It is a PDF.
Two great networks, one trusted name. CBS has a new home with WIFF4. Looking for your favorite CBS shows? Find them on WIFF4.3 or your TV provider. Go to WIFF4.com/CBS for more channel information.
It is a PDF. And here it is. This is it. Yes, okay. So it's the Texas Code of Judicial Conduct, and this is amended by the Supreme Court of Texas through June 12th, 2026, okay? So this is official, all right? So you can Google it the same way, Texas Code of Judicial Conduct. This is the code that governs how judges are supposed to behave. So all of the rules that judges must follow while they're on the bench, that is what's covered here in this document, all right? And so the first thing that they raised in this case wasn't even Canon 2, it was Canon 310, 3B10. This is 3B10, I've already highlighted for you. Let me make it bigger so you all can read along with me. All right, let me get this off. Okay, so this says, this is the judicial code, so judicial canon, and it's 3B, number 10. It says a judge shall abstain from public comment about a pending or impending proceeding which may come before the judge's court in a manner which suggests to a reasonable person the judge's probable decision on any particular case. This prohibition applies to any candidate for judicial office with respect to judicial proceedings pending or impending in the court on which the candidate would serve if elected. A judge shall require similar abstention on the part of court personnel subject to the judge's direction and control. This section does not permit judges from making public statements in the course of their official duties or from explaining for public information the procedures of the court. This section does not apply to proceedings in which the judge or judicial candidate is a litigant in a personal capacity. All right, so that's the first judicial canon that Russell Wilson raised that the judge violated. And as soon as I started reading it, you're like, wait a minute. The first sentence, a judge shall abstain from public comment on a pending or impending matter. Now, most would feel the verdict had already come down, so the matter was no longer pending. It was impending because, one, the defendant has rights to bring this motion for new trial within 30 days of the verdict. And everyone knows the motion for trial is filed in the trial court. And a lot of people were confused, like, oh, it's an appeal, this is they're two separate avenues. Yes, we sometimes generally refer to everything that happens post-conviction as an appeal. However, the first line of a defendant's appeal is to file a motion for new trial, and that's in any conviction. You get convicted for DUI, if you get convicted for battery, if you get convicted for murder, you get convicted for aggravated assault, you get convicted of armed robbery, your representing attorney automatically knows that most times if that happens, we go ahead and file it the night the conviction comes down. Right. It's boilerplate. But you have 30 days to file that motion for new trial, and that's back before the trial court. After you have that motion for new trial, which most times is denied because the same judge that had the case is the one that's going to be hearing this motion, then you file something in the appeals court. So Karmelo filed a notice of appeal the night of the verdict and was appointed an attorney to represent him on that, which would have been something in the appeals court, but he also had this 30-day right to file a motion for new trial. This would have been explained to him on the record at the time that he took a plea. So this is not something the judge didn't know. Judge Roach knew this. Okay, so when you know that something could come back before you, it's impending. So therefore you cannot speak on it. Now it sounds like the judge was in direct violation of this canon. However, Judge Hall did not find that way. Okay, so that's how the argument opens. So each argument that Russell Wilson is making, he is using a PowerPoint slide to do so. All right, so that's the first one he comes out with. He talks about this interview and the judicial canons. He then says, Judge, in our recusal motion, we are in our motion for new trial, we're also arguing that a Sixth Amendment public trial. The judge in his interview is saying him closing the trial was done correctly and that he followed the law. He can sleep well at night because he followed the law. And so if I'm then going to present to you, Judge, we don't think you followed the law. Waller and Presley says you need to do this and this and this. And the judge, is he going to be unbiased? Or, I mean, he already said on the record that he followed the law. So he's kind of already telling us how he's going to rule, right? That's what the canon said, that you shouldn't make statements that lead to that tend to show someone how you would rule on something, right? Because you're supposed to be unbiased. So that was another argument they brought up. They didn't really get too deep into that motion for new trial because it's tomorrow, but Russell Wilson wanted to bring it up to say, Judge, this is going to be part of what we discuss tomorrow. So we don't need Judge, Roach on it if he's already showing a bias in his interview. Let's see what was next. Oh, he also brought up the fact that Judge, he talks about in the interview, remember that statement about maybe I could have done an audio room? In the trial, the first 2 days for Dyer, he actually had an overflow room. He actually had one. And then day three, because they took a break. Day three, when the trial starts, then the overflow room is closed. They had an overflow room open today, And Russell Wilson pointed that out, so it can be done. So there were alternatives that you could have considered. You failed to do so. So that's their public trial argument. But I'll come back to that. So they raised that just to say that the judge is already saying in an interview he did everything right. So he's not going to be unbiased when we present these arguments to him tomorrow. Let's see.
I'm partnering with Chase Freedom Unlimited to make New Yorkers' days a little bit better. And along the way, I'm getting 1.5% cash back. Today, I'm buying people coffee.
Tomorrow. Let's see. They also talk about how the interviewer asked him about, the media is part of the public and how the judge tried to separate the two, but really it's all one and the same, and how, again, he's speaking on the very issues that they're going to be asking him to consider in the motion for new trial in this interview, and kind of doubling down on his stance. And so that shows a bias. So the judge should not make public comments. The interview were public comments. The topics were directly related to the motion for new trial. Let's see. And so they were arguing that the judge has already publicly declared a judgment on the very issues. And then they go to canon 2A. So let me go back to the canons, because they also argue he's in violation of canon 2A. So this was 3B10. Go back up. I already highlighted it. 2A. 2A, canon 2A, and this is the judicial code of conduct. It says a judge shall comply with the law and should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. So that was the second canon that Russell Wilson argued that Judge Roach was in violation of. They then, they say because he's on TV making statements about Facebook, okay? So you all recall that during a part of the interview, they asked him, what did you think about the social media buzz and all of this? Did you pay attention to any of that? And he's like, no, I didn't pay attention to any of that. I didn't pay attention to the public, in the trial. I come through a back entrance. So, the jury and I we were away from that. But then he comes back to speak on the Facebook comments about him knowing the Metcalf family. And so he says, there's comments on social media about me knowing Jeff Metcalf, and I wouldn't have known him prior to the trial if he walked past me on the street. People put up these AI photos, and you just, social can't really believe anything you see on social media. So he was explaining something that is being stated on Facebook. No one has ever raised an issue of him knowing the Metcalfs in the actual Karmelo Anthony case, none of the attorneys or anything. So they say he felt the need in an interview to defend himself against social media rumors. And so they're saying there have been ethical opinions that have come out and state how a judge should act. All right, so there were four ethical opinions that were attached to this motion that they entered into an exhibit today. I'm not going to go through all four, but I did pull up one, and I'm just going to show you kind of, how those ethical opinions work. So I've shown you the canon. So the canons show a rule, and it says a judge shall not do this. But there are questions that have come up, like, well, can a judge do this? Can I, go on make a statement about a case about this? And so if it's an unanswered question or something where the law is silent on or rules are silent on, it'll be a question that's opposed to the Supreme Court. And if they deem that it's never been answered before, they will issue an opinion. And that opinion will tell people how they're supposed to behave when they're in this situation, okay? Well, I tell you, the law is so deep, it's a lot when it comes to being a lawyer. It's not just, reading one code section. You have to go to cases and see what the rulings were. The Supreme Court issues ethical opinions that tells you how to behave. It's a lot, okay? So hug your lawyer, okay? Hug your lawyer, it's a lot. So let me go show you this, let me see where this opinion is. Give me 1 second. I have a lot of tabs because I wanted to show you all everything I mentioned. Oh, here it is. Okay. All right. So this is the judicial ethical opinions. And I am going to, let me make this a little bigger. Go to opinion 209. That was the first one reference. And so remember I told you that these opinions are issued when someone has a question. So this opinion came out in 1997, and it's about the judge's response to negative publicity. The question says, may a senior judge who presided in a massive tort litigation action respond publicly while the case is still pending to unfair criticism of his actions in the case, including allegations of bias because of personal ties to the attorney for the plaintiffs and suggestions that the judge's political interests favor plaintiffs who mostly reside in the judge's county. That's the question, right? Kind of similar, right? It's like, can a judge come out and publicly respond to unfair criticism about him knowing the Metcalfs, right? You can put Judge Roach's question into this opinion. This judge feels the need to defend his reputation now against these false accusations, even though the matter is still pending because of fears the litigation may not be concluded during his lifetime. The Texas Supreme Court said no. Simple as that. They go on to explain, but no. You can't do it. All right, and so he says a senior judge who is considered to accept judicial assignment has to comply with the code of conduct. And they say this because there are some canons that don't apply to certain judges. So that's why that first sentence is there. I'm not going to read through all of this, but they go through and explain why the judge is precluded from doing this. But this is exactly what Judge Roach did in this case, and that is the defense's argument. They are saying opinion 209 says you cannot go out and clear up unfair criticism. And that's exactly what the judge did in his interview, right? He spoke on Facebook rumors that he knew the Metcalfs. He felt the need to clear that up, and it's still pending litigation because you have this motion for new trial that can come before you. At the time you made the interview, it had not been filed, but the defendant had that right. So you know that something can come before you, so you're not supposed to speak on it. So they are showing distinctively how he's violating judicial canons. So the judge's ruling was very interesting, and I'll get to that. All right, TKO every time 19, shout out, thank you, sends a $5 super chat. Thank you so much for that. Says during jury selection, when a juror asks, "What if we can't agree?" Roach said, "Don't try that here. Isn't that interfering with deliberations?" Well, no, only because they weren't deliberating at that point. But I see your argument, right? Because other jurors that potentially could get on the case could have heard that and felt like, we won't be able to not agree. The only reason that argument probably wouldn't stand is because that's happening in voir dire, right? That's happening at the very beginning. The jurors haven't even been selected. Once the jurors are selected, they are sworn. They are giving the law to follow before they deliberate. So they are, charged with coming to a unanimous decision. But if they don't, then they don't. And you also can poll the jury after they give a verdict. So I see where you're going, and that is, I feel as well that his comments to Karmelo about testifying, and I'll talk about that in a motion for new trial, were inappropriate as well. Judges don't have to be perfect, right? They're not going to be perfect. They're not going to get everything right. But, he's just like, it was a lot of social media stuff going on. Judges like, hey, don't come in here, trying to hang the jury, talking about that from day one. Like, don't poison the jury pool with that kind of talk. Is probably, where he was going. But thank you so much for tuning in, and thank you so much for that super chat. Let me see before I go on. Any more questions? Thank you all so much. I think we had 309 in the chat. Make sure you like, share, and subscribe. And definitely give me a like and a subscribe. They're free so that we can get into the algorithm. Let's see. All All right, so let me keep going. Oh, Chicken Chow Mein 77 says, isn't it possible that with a new trial, Karmelo could get more years? Oh, yeah, I already answered that question. So, yes, that there is a possibility, but I also really explained it because it's a possibility that it could go way the other way, right? Because it's going to be a totally new trial. All right, yes, it sounds like he wanted his 50. And so true, 007, I think what it was is that he felt really proud, right? Because this was the biggest case that they had in Collin County. And he was in charge of it, and for 8 months he prepped this case. And so he even said in the interview that this is going to be a case that America can use as an example of how we handled this case, right? So he was very proud about how that. So I don't necessarily think like this 15 minutes of fame per se, but he was very, very proud of the job that he did. And I don't think he thinks he did anything wrong. You can tell by the way he talks about the case that he's a very good judge, right? I don't take any of that. I haven't heard anyone come out and say, unethical things about him. It's just that some unethical things happened in this case, right? He wasn't thinking. He's thinking it's over with. The verdict's here. I don't think he acted maliciously, but you are doing some things that violated the law, which means you gotta go. All right? And so they go through these ethical opinions. As I say, I pulled up opinion 209, and you can see how the judge kind of violated that right, feeling like he had to make public statements about criticisms about himself. Let's see. Oh, and they also slid in that there are no pretrials hearings from this case on the record. And they brought up that the judge said that he was concerned about a witness's testimony, but there's no record. So the no record part ties into like a big issue for this case. There were pretrial hearings held in the judge's chambers with no court reporter. That is a big legal issue, okay? The Presley case, I think it's Presley or Wallen, we'll pull those up, speak directly, was, directly dealing with a motion to suppress. And it says that, it has to be public. You can't have hearings that are secret, right? And you never have hearings without a court reporter because now the trial's over. Karmelo has this dream team appeal squad, right? And they're filing this appeal with no record. They don't have any record of any of the pretrial hearings because they all happen in chambers without a court reporter. So that is why in the motion for new trial, you see Mike Howard's affidavit, because without him writing this affidavit, we don't learn anything about this gentleman's agreement, which shaped the entire defense of this case and was the reason Karmelo didn't testify. All right, so let me finish going through the motion for new trial. The motion to recuse.
Your time is valuable. You could finish your degree faster and for less with eligible transfer credits at University of Phoenix.
Come on. Oh, boy.
Here you go, Bubba.
Come on. Damn it.
They talk more about the things that are going to come up tomorrow in the motion for new trial and how just the judge kept speaking to things that are going to come up tomorrow that show he has a bias. All right, so the state's turn. They get to go up. And the first thing Bill Werski says is, Judge, I've been practicing a long time, and I've talked to all the attorneys in my office and the appeals team, and we just don't think it's our job to defend Judge Roach. So we don't really have much to say today. This is a defense's motion, and it's up to you to make the decision, but we're not here to defend Judge Roach. So,
By cockroach.
Don't really have anything to say. And then he went on to say, I know Judge Roach. I've known him personally. I've been a defendant before him, and I've been a prosecutor before him. I've defended capital crimes. I've prosecuted cases. He's always been fair. He went on to explain that he believes that in the interview, when the judge says, got it right, that he was meaning the jury was picked, the case was tried, and they got a verdict, and that was the rightness. And if you remember from the first canon that I showed you, it says that a judge can make public statements if it's about informing the public about procedure. And they say, Judge, those statements were simply informing the court about procedure, not speaking to if he felt like the jury was absolutely right and Karmelo was guilty, it was just explaining that they got it right because they heard the facts and got a verdict on the case. Shout out to JWash0622 says 10 Jules. Thank you so much for your support. So they, that was his explanation. And he goes on to say, like, Judge Roach has a dedication to fairness. He always has. Let me see. Oh, he says that, Judge, you have to understand that there was a concerted effort to disrupt the trial, that some of those online people are here today. So Bill Wursky actually made statements about the YouTubers, TikTokers, content creators that he feels purposely set out to disrupt the trial. Said some of them were in the courtroom today. I don't know who he was referring to. He did bring up AI pictures and false reports. And I learned, if you weren't watching Dennis Byron's live earlier, that he was referring to Dennis and he explained all of that. But I didn't know at the time that I mentioned it on his show. So there were no shots there, Dennis. Sorry. He says, that all, and then he kind of says this kind of, like his tone got, I guess, like deeper and a little more aggressive. And he says, and he kind of like tossed down his pen, like, all things put in place were agreed upon by both parties, Judge, the state and lawyers number one. So that Mike Howard and Toby Shook are being referred to as lawyers number one. And he says, basically, Judge, like, these appeals attorneys can say all they want, but the defense attorney originally agreed to all of this, Judge. So all of this was agreed upon. And what he's referring to are the restrictions that were put in place with the courtroom being closed. And he says that both parties wanted these restrictions put in place, and that although it's not in the record, because mind you, there's no record of any pretrial hearings, there's no record that both sides wanted this. He says that they drafted a proposed order that they were going to file at the end of the trial that put all these findings of facts in it, but it was never signed. Like, what? It's just, it's like they were just trying this case like they were at the water cooler. And they thought that Karmelo was just going to get convicted and go to the back, and they were never going to hear from him again. That is exactly, how it felt as he makes these statements. Who drafts an order with findings that are required by the law to be in place, never signed it, never gets filed in the record, but Judge, we were going to do it? Like, what? The fact that he even stood up and made that argument, and the judge says, I don't have that. It's not part of the record. To cut him off is like, don't even start trying to tell me all of the backdoor, underhanded, never filed things that happened in this case. Oh my goodness, shout out to, let me not mess this up. Speak on it. What was it? Dama the Tree, speak on it? I know I'm probably messing this up, but I do. Dama the Tree, speak on it. Please tell me in the chat, y'all. I hope I don't mess that up. Thank you so much for this $100 super chat. I greatly appreciate your support. Thank you so much. Thank you so much for tuning in, right? Just came out here so I could be inside and give you all the commentary. So thank you so much. No comment, no question, just for the pure love of the game, and I appreciate that support. Thank you so much. Thank you for that support. So yeah, so Bill Wursky's like, hey,
When dry eyes need a boost, up to 10 hours of relief to help you keep going. Relief with every blink.
for that support. So yeah, so Bill Wursky's like, hey, oh yes, and shout out because you are the stream sponsor. I'm going to add you to the banner. So thank you so much for that. Let me get ready to do that. But yes, he's like, both sides agreed on this, Judge. So I don't know why they're saying something now. Lawyer number two saying something, but lawyers number one, they were with it. But just to hear that, pretrial hearings occurred in chambers and they weren't reported by a court reporter. I'm gonna say that because we're gonna get into that. That's gonna come up tomorrow for the motion for new judge like, you know what? There's no record of that. I don't have the record. And then, let me see. Let's see. All right. So then Judge Hall comes back into it, and he talks about how, you know, he's from the outside. That he doesn't know Judge Roach. You know, they may have seen each other at conferences, but he comes from San Antonio. Somebody in chat can probably say how far away that is from Collin County. Texas is huge, so hours away. He says that prior to the hearing started, he told the attorneys, you know, I have to make this decision today quickly because there's a motion for new trial tomorrow, and based on my decision, that is how we'll know who's going to hear the hearing tomorrow. So I need proposed orders from you both. So depending on what my decision is, I'll be able to sign and go. That's what he said at the beginning of the hearing before they started. At the end of the hearing, the first thing he started saying when he started talking about this, I don't know Judge Roach personally. I'm from outside of Collin County. Rule 18A, 18B are very high bars, and this is basically the disqualification and recusal of a judge that Russell Wilson was arguing. The judge said, I am finding no violation of the canons. That, I'm going to use the right wording, because this is the test on a recusal. He said, I am finding that the test for a recusal motion, which is whether a reasonable person, knowing all the circumstances, would harbor doubts about the judge's impartiality. Due to the interview and statements made, I find that a reasonable person, knowing all the circumstances, would harbor doubts. And for that reason alone, I am going to recuse Judge Roach. Do not put anything in any order about a violation of a canon. He said he sits on the Judicial Committee and he will not sign anything that says that Judge Roach violated a canon. However, as I have shown you the canons, it seemed clear to everyone in the courtroom that there was a possibility that Judge Roach may actually be in violation of those canons, and I'm going to pull those up again. Canon 2A says the judge shall comply with the law and should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. The interview, Russell Wilson argued, doesn't do that. All right, you see the interview and you feel the judge's bias. Canon 3B10 says a judge shall abstain from public comment about a pending or impending proceeding which may come before the judge's court in a manner which suggests to a reasonable person the judge's probable decision on any particular case. Now remember I told you there was a section in here that does allow. This section does not prohibit, meaning it allows judges to make public statements in the course of their official duties for explaining for public information the procedures of the court, right? So it doesn't prohibit them from doing that. So they can do that in their official duties or to explain things to the public, but that's not what was happening in that interview. That's what he ruled, and that is why he recused him. However, he said he was not finding any violation of the judicial canons and implored the attorneys not to put that in their order. All right. So shout out again to Dominatrix Speak On It. I hope I said that right. Thank you so much for the $100 super chat. And Sonia Parker S8B sends a $5 super chat. Again, no question, comment, just for the pure love of the game. And let me see that I miss any other. Tyrone Phillips 9872 sends 20 jewels. Thank you so much. He also sent 10 more jewels. Thank you so much. Yes, I did answer that. Thank you so much, TKO Every Time 19. Jay Wash sent 10 jewels again that I missed. All right, I think I am caught up now. Let me add to the banner. Give me 1 second. I don't know. I'm gonna have to. Okay. I'm trying to do too much at one time. I don't know how Lee does all of this. Supporting this show. Okay, I'm doing too much. Okay, I'm gonna update it. 1 second. All right. It's like, let me write down. Alrighty. So, do I see any questions? Could he be found in violation in the future? No. This is over with. The judge has ruled on this, so you don't get to come back again. And it won't be. And it's a moot point. I know someone was asking me earlier, like, should they appeal this decision so that the judge could be found to be in violation of canons? And it's like, what's the point of that, right?
There are trucks, and then there's the 2026 GMC Sierra. It's the truck. Get 2.9% APR for 72 months plus $1,500 purchase cash on Sierra models.
Modern women, millennial women, are quiet quitting their marriages.
These women are staying in marriages when they actually could leave.
So why did this concept resonate with so many women?
The term quietly quitting gave people a voice to what they were already experiencing.
The mental load of managing the house and being the CEO of the kids, I feel like I'm treated like I'm Google.
You're speaking for a lot of women right now. As you're saying this, I'm thinking all the women are saying, aren't we managing everything? Yeah.
For the longest time, I was like, do you even like me?
Wow. I'm getting emotional.
Women in midlife are saying to their husbands, you haven't changed, and I'm evolving. You're not growing, so this relationship's not growing. They're stuck in stasis, and the women are ready for their second act.
Look at all the amens.
To be in violation of canons, and it's like, what's the point of that, right? You got what you wanted. The judge is off the case. Move on to the motion for new trial. So that is what is going to happen tomorrow. Okay, this banner. All right. So tomorrow's hearing is going to be on the motion for new trial. All right. And so let's get into that, because I saw someone's question earlier that said they kind of didn't understand, like, why we're here. He was convicted by a jury. I don't understand what's going on. So let's get into that. All right. So the motion for new trial was filed on July 7th. Whenever you're convicted for a case, convicted of a crime, no matter what it is, you as a defendant have a legal right. These rights are granted by the Constitution, so whether you like it or not, you can't do anything about it. A defendant has certain rights, right? You have the right to remain silent. You have the right to presumption of innocence. You have the right to a speedy and public trial. You have the right to have an attorney represent you at this trial. You have the right to cross-examine witnesses that testify in court. You have the right to present any evidence in your favor. There are certain rights that you get as a defendant in this country. Okay, so no matter what you're charged with, these rights apply to you, and you get to exercise them if you choose to. One of those being is to appeal your sentence, conviction. You can file a motion for new trial within 30 days. You can file a direct appeal if there's a legal issue there. You can file a habeas if you need to file one of those, and that's challenging the constitutionality of your plea, sentence, or conviction. So a defendant has certain rights, so that's what we're here. So let's, no matter how you feel about the case, no matter which side of the case you land on, the defendant is granted certain rights, and Karmelo is exercising those rights by going forth with his motion for new trial. Okay, so that's how we get here. Next, we have the motion for new trial that's filed, and once it's filed, the law says, guess what? He doesn't even have to have a hearing on it. The court could sit quiet on it for 75 days from the verdict, and then it would be dismissed by matter of law. So if no hearing had been granted, this would just have been dismissed by matter of law come August 23rd, and he just would have had to move on to his appeals. But of course that wasn't going to happen, right? Because the public is too invested in this case, right? Their outrage that would have occurred if that had have happened just would have been too much. So that didn't happen. The hearing was set. Karmelo's legal team asked for the hearing to be held by the 21st, although technically it could have been on Monday, because whenever a deadline falls on the weekend, it's extended to the next business day. So that would have been Monday, but they asked for a hearing, and the judge set that hearing for tomorrow. So that is when the motion for new trial will be heard. Shout out to Jalen8264. Shout out, sis. She sends $10 super chat. Thank you so much, Jalen. You sent jewels. Now a super chat. I greatly appreciate your support. Thank you so much. No question, no comments. Just for the pure love of the game, and I greatly appreciate that. And then she says 1,000 jewels, a gold trophy. I gotta research these jewels because I'm not up on them. But I'm like, oh my God, that's a lot. Thank you so much. Thank you so much for the support. Khadijah2748 says you will be an excellent law school professor. Oh my God, look, now don't speak it into existence. I never thought about that before, but I do enjoy this. So maybe that's up next. We'll see. If I do, I was gonna go somewhere petty, but okay, let me stay focused. Y'all, let me stay focused. Alrighty, so let's get back to the motion for new trial. So the defendant has this right. So the law says it has to be heard. So it's set for the 21st. We didn't know going into the court today who was going to be handling the motion for new trial because it all depended upon who was going to be, left. If Judge Roach had not been recused, he would have been hearing it. But Judge Roach has been recused, and I'm going to show you all the new judge that has been appointed to hear this case. It came out, and all right, let me share my screen. It is Judge B. Michael Chitty. I'm going to say, Chitty probably is how it's pronounced. So he is a retired judge. He was a judge for the 422nd, I guess that's how they say it, district court. It's so weird with all these numbers. I don't even get the numbering system because 494th district was right next to the 199th district court. I'm like, I don't understand that system, but it's different in every state. Georgia, Fulton County, we on 3A, B, C, D, E, F. That's it. So I don't get all the numbers, but he's out in Kaufman County, which is not Collin County. So this is a judge that's out on the outside. He was appointed back in 2004. He retired December 31st, 2020. And a lot of times you retired judges brought on to hear things.
So I would ask the board, what if our next app wasn't slow?
Your judges brought on to hear things all the time. So this is not unusual that they're using a retired judge.
Right.
We do that in Fulton County all the time. Judges retire, they lose elections, and they come back as what we call them senior judges. And they will choose to hear cases. Maybe they're brought in like substitute teachers. Like if a judge is out on vacation, the retired judge or senior judge will be appointed to hear things. So just because you're retired from the bench as a full-time judge in your seat that you were elected for doesn't mean that you stop being a judge. If you weren't in violation of canons to where you lost the ability to be a judge, right, then you can still be a judge and preside. And so he is coming into town to hear this motion. I am thinking he probably had the heads up because this is a lot to read. It took me a few days to read this motion for new trial, to go research the legal cases. He is not doing this in 5 hours, okay? He probably was already told that, hey, if Harl recuses Roach, then I'm going to tap you in to cover this motion for new trial, so go ahead and read and catch up. I can only imagine that's, and he'll say it because Harl spoke about having already read the motions, already read this, getting caught up to speed. So he'll make those same announcements tomorrow. But I'm guessing that just has to be it. I just can't imagine he got a call today at noon to say, hey, be in court tomorrow in Collin County, hours away. No, he probably was already down the street in the hotel, just hold up trying to see if he was going to be tapped in. And then, truthfully, I'm sure Judge Harl already said, I'm recusing Roach. Judges already kind of talk about this stuff. It wasn't any more evidence that was presented. It was just argument. That interview was clear cut. I think every judge across America who's spoken on that has said that they will recuse him. So this is probably already set up, and we just are getting informed. But I'm sure that Judge Chitty already knew that he'd be tapped. Now, what did pop up, I'm not from Texas, so Drake Prado, I think that's how it's pronounced. But yeah, it doesn't mean anything to me. I don't know anything about this case, but I saw that there was a case that he handled back in 2019 that he ruled. It was something where CPS came in and took a 4-year-old from their parents without following proper procedure. There was a hearing before this Judge Chitty, and he ruled in favor of CPS, even though there was overwhelming evidence that they didn't follow whatever the 3 rules that they were supposed to follow before they remove a child. I mean, they gave no notice to the parents before the removal, and the case went all the way up to the Texas Supreme Court, who then overturned Judge Chitty and said that he was wrong in his decision, and the child was then given back to the parents. So I say all that to say this could be a great thing because no judge likes to be overturned, okay? And so judges don't like to be correct. If you listen to Judge Roach's interview, he said over and over, as long as I follow the law, I can sleep at night. As long as I get it right, I follow the law, I'm good. So judges don't like to be overturned because they think that they are doing the right things. They want to follow the law. So when you are, that is something that's in the history books forever because it's now that opinion that was issued by the Texas Supreme Court becomes a part of Westlaw. So like I could go pull it up, and this now sets a precedent of how things will occur. So, they don't like that, right? So I think, having that happen in such a big publicized case that you're going to really want to make sure you follow the law in this case and err on the side of caution, which may help Karmelo because their first legal argument of the motion to new trial is a bombshell argument. I know that the defense is going to have things that they say back, and we even saw a little bit of that today when Bill Worski was like, hey, both sides were cool with this. Both sides were cool with how this case was ran. Both sides were cool with the restrictions on the courtroom. They both wanted it, okay? It's not in the record, but that both sides wanted it. So that, that's going to be some of what comes up. So the motion for new trial was filed. There are 4 legal issues raised in this motion. I believe the actual written motion part, because it had exhibits attached to it, was about, I think, like 58 pages. Let's say like the first 45 pages or so was the first argument. So when I tell you this is the defense's big legal argument, and I've never heard this argument made in court before. I did read the legal cases that they cited in it, and I did a PowerPoint. I'm going to show you, what's required by the cases cited. But you just never know how things are going to go, but it's a really strong argument. And the biggest part of this argument, the Supreme Court of the land, okay? So these cases that they're citing, Presley versus Georgia, Waller versus Georgia, those are cases that went all the way up to the Supreme Court. So it is the rule of law. And if it also says that if the trial court, if Judge Roach violated the law on this Sixth Amendment right to a public trial, that Karmelo gets a new trial, period. It's not a question. It's not, if you're only charged with something and somebody didn't die. No, the law says no matter what, capital murder, that's not what Karmelo has, but all the way up to capital murder, it will be overturned. And the defense actually cites 2 cases from 2026 in their motion out of this very court, the appeals court that will hear this case if they decide.
It was just what I needed. Just a pool and some poolside service. The card that's preferred for a reason. Chase Sapphire Preferred.
At Chamberlain University, we know that competence and compassion go hand in hand. That leadership
Courts, the appeals court that will hear this case if they decide not to deny it, not to grant the motion tomorrow, that overturned convictions, one being a capital murder case for this reason. All right, so let's get into it because I saw some questions about it. So the argument is that the Sixth Amendment grants the defendant a right to a public trial. People hear that and say, well, people could come into Karmelo's trial, so it was public. And this is where how I showed you that case law will come down and further explain things, or how an opinion will come out and answer a question that is
Okay,
that
so
we don't
let me
have
be
an answer
clear.
to. So it explains what a public trial means. And the law says that whenever you place restrictions on the courtroom, and I don't think that anyone can truthfully argue that there weren't restrictions in this case. There was an order put out in April of this year, in advance of the trial, that said that there would only be 9 legacy media allowed in, that there you couldn't bring in any computers, any electronics, that members of the public couldn't bring in any phone, that they were going to allow, what they say, they're going to allow media inside, seats for each family, court personnel, which was only going to leave about 27 seats for the public, okay? So that is a restriction. That is a limitation on a court. I've been practicing for 20 years. I've tried cases before, and we don't have to address how many people can come because there's not a lot of people that are trying to come to every case, right? There are trials every day in every courtroom, and it may be one person from the public, if anybody. Sometimes you don't even have the defendant's family there in support. So there are not orders put in place in every trial that says who can come in and who can't. So the minute you do that, the law says that you have to follow certain requirements. The defense is arguing that Judge Roach did not follow those requirements, okay? So I'm going to pull up what those requirements are so that we can get an understanding of, let's see now, I have it on a PowerPoint. How do I access? That's my first time doing a live from my laptop. Not at home in my studio. I'm like, how do I? Okay. Oh, there we go. Alrighty. Okay, so the first case that they reference is Waller versus Georgia. This case is out of my home state, Georgia. I believe both of these cases, one is DeKalb County and one is Fulton. I can't remember right off, but they're both out of Georgia. They were cases where Waller was convicted, Presley was convicted, then they filed an appeal. The appeals court said one thing, then they took it up to the Supreme Court. So these cases are Supreme Court cases that have been ruled on, okay? The citation under 467 U.S., that's United States Supreme Court, like that lets you know it's a Supreme Court ruling 39. You can just Google this citation, it'll pull the case up for you. It's from 1984. And it says that when a judge is closing the courtroom, putting restrictions, now, not locking the door, it's not, Marvin Sapp, close the doors, like don't let anybody out the church, no, not that. But just when you're putting restrictions, because courtrooms are open to the public. Anybody can walk into any courthouse any day, wherever they are, and go into any courtroom and sit down and hear whatever's going on. So courtrooms are public. So whenever you put any restrictions, if you say only 10 people can come in tomorrow, or you put different, we're going to have media, we're going to save these seats for this people, I'm only going to give the public 27 seats, I'm only going to, that's a restriction, okay? The law says that when you do that, the parties seeking to close the hearing must advance an overriding interest that is likely to be prejudiced. That's the first prong, is that, first off, what's funny in this case is no party sought closure. The judge issued this order closing the courtroom sua sponte, meaning of his own free will, the same way he did the gag order. So there was no motion by Mike Howard filed that said the defendant would makes an argument for the courtroom to be closed because we feel in the interest of blah 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 this needs to happen. Bill Worski didn't file a motion and say, Judge, this courtroom needs to be closed because we feel that the kids are going to testify. There's no motion filed. So all of that backdoor, gentleman's agreement way that they tried this case is going to come back to bite them, right? So there's no motion. So nobody made this request. So no party, because the judge isn't a party to the case. It's state versus Karmelo. Those are the parties. So no party raised this issue and made an argument about an overriding interest being protected. Overriding interest being protected, okay? But let's say that ain't an issue. Let's say the judge could make the decision. All right, did the judge, what was the overriding interest? He spoke in the interview that he had kids testifying, but he said that wasn't something new, right? Kids teach the kids testifying all the time. But he said he was concerned about having cameras inside because when he's seen people have cameras inside courtrooms in the past, and it makes people act differently. The judge acts different. The attorneys act different. People want to put on a show. Guess what they don't do then? Okay, did you consider an audio feed? And then he has this thought during the interview. Oh, I could have considered an audio feed. Well, that is what the law required you to have this hearing to discuss all of that. So you could tell us what overriding interests were you protecting by the restriction. So that means that your order that you present should say, in protecting the interests of blah, 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 I decided to restrict the courtroom, okay? The order does not say that, all right? Let me go back to and show you the second part. Number 2, it says the closure must be no broader than necessary to protect that interest. All right, so hang on to that sentence, because if you'll recall, like in the YSL trial, where some people didn't want to be seen. There were undercover cops that testified. And so when there was a camera, it would have to cut off of them. It would not show their face, not show their body, not play their voice sometimes, or sometimes it'll put a voice changer on the person testifying, right? That would be or it could even, there are times in cases where kids testify in chamber, under camera. They go back and the judge interviews them and talks to them, and it's not before the public, right? So that's closed, right? But it's not the whole trial. It's just that one interest you're trying to protect. So the law says, show us what the interest is you're trying to protect and keep the closure limited to protect that interest. A case that the defense referenced in the motion for new trial was a motion to suppress hearing, where the state was trying to get in some wiretaps. And the law said if wiretaps are played in court that are irrelevant to the hearing, they are now excluded from ever being used. And so the state was saying these wiretaps apply to some people who haven't even been indicted yet, Judge. So we want to keep this closed so that it doesn't get out to the public. They can't get informed, blah, blah, blah. And so the court closed the motion hearing for that reason. Well, this hearing went on for days, right? But the time that they only talked about the wiretaps was like 2.5 hours. So they're like, you don't close the hearing for 7 days when the only issue was like 2.5 hours. So the court overturned. The court in that case sent it back to have that motion hearing again in public and close it and limit it. And if something changes by the hearing, like if this evidence gets suppressed where it came in before, then we'll overturn the conviction, right? So that wasn't an automatic overturn of conviction because it was a limited scope. Well, in this case, guess what? It wasn't public. The trial had restrictions and the pretrial hearings had restrictions because the pretrial hearings were held in the judge's chambers without a court reporter. Judge, last July 28, 2025, this incident happened April 2nd, 25. The judge put in a gag order in place. This gag order said no one can make any public statements. So because of that, and because of all the social media attention, the judge was concerned that every time a filing would hit the docket, we'd be pulling it and we'd be going live and live, and somebody else will post on Twitter. It would just be out there. It would be a constant, a media reel about the case. He wanted to stop that. So he had them hand deliver motions and not file things in the electronic filing docket so that he could keep it from the public. So the public wasn't even made aware of when hearings would occur because we can attend those. The defendant can have people attend public hearings where they're hearings on this extrinsic evidence that they said they could bring in on Karmelo Anthony. If it wasn't, I got a problem with that because the law says that you can't just waive 75 pages and say, this is extrinsic evidence, we're going to bring it in. It has to be a hearing on it. But guess what? I don't know if it was a hearing or not because none of these hearings were put on the record. They were trying to keep the docket clean. They wanted to keep everything off the books, right? So without a court reporter, so there's no record of any of this.
Control
and so
everything.
that's an issue. And so they're saying, Judge, look, all of those, the law says that that's not public. And these things have to be met in order for you to be able to legally do that. Let's go back to number 3. Let's see. So the defense is arguing that Judge Roach closed the courtroom and didn't put these findings on the record. The trial court, number 3, must consider reasonable alternatives to closing the proceedings, right? In the interview, he actually says as he's talking, oh, you know what? Maybe I should have done an audio feed. That is a consideration for reasonable alternatives. You know what else happened? There was an overflow room like we had today set up for day 1 and 2, the voir dire, when they were doing jury selection. But then on day 3, it stopped. Why? Did the power go out? Did the system go down? Why weren't you running a feed to the overflow room for the trial? Every witness that testified wasn't a child. Cut the feed when it's the kids testified. I mean, like, what was the reason? What was the alternatives? What did you consider? The law says you got to put that stuff on the record. It wasn't in the order. Lastly, Waller says that the trial court must make findings adequate to support the closure. So, and when the trial courts, when this order says that the trial court must make findings, baby, these findings have to be on the record. Now, I'm going to tell you how serious they are about that. The YSL case. I'm working on the appeal for Antonio Sledge down in Fulton County. We filed an appeal because his sentence was void. They gave him too much time. They just mucked that entire case up. So the judge, Whitaker, she agreed with us. And she voided out that sentence and she resentenced him. Now, she did make errors in the resentencing because he wasn't brought into court, but she didn't put in the order why she agreed with us that the sentence was void. So guess what the appeals court did after we waited on a ruling for 8 months? They said we're remanding the case back to the trial court to put findings of fact on the record in the order so we'll know how you got to your conclusion, because we can't rule on the appeal till we understand how you got here. So when the law says you have to put findings of facts on the record, that is why, because when the appeal courts reviews the record, they have to understand how you got here so they can then decide if it was legal or not. You see what I'm saying? So findings of fact have to be put on the record. So what the defense is arguing in their motion for new trial is that Judge Roach failed to do that. Second part of that argument is the Presley versus Georgia case.
For over 130 years, Strayer University has been making education affordable and attainable.
Do that. Second part of that argument is the Presley versus Georgia case. That was a 2010 case, again, out of Georgia, went all the way up to the Supreme Court, and you know that by the citation, U.S. 558, U.S. 209, 2010, you can pull the case up. It says that the Sixth Amendment's public trial right extends to jury selection. This was a case where someone was going to trial, and their one family member that showed up, the judge put the uncle out of the courtroom during jury selection and said he couldn't be sitting that close to the jurors, so he put him out. So basically no one from the defendant's family was able to be present for jury selection, and the court, despite the charge, despite the conviction, said yes, that's a violation. It extends to jury selection, not just the trial itself. And it's double down. You have to consider reasonable alternatives to close your sua sponte on its own. So, like, even if, because y'all probably thought, well, the judge can decide it on its own. He can. One party doesn't have to raise it, but the court says that even if you do it sua sponte on your own, you still have to consider reasonable alternatives. And even when neither party proposes alternatives, you still have to consider it. So it puts a lot on the judge in making that decision. You have to do these things. And the defense is saying, Judge, you didn't do it because it's not in the order. If it's not written in the order, it didn't happen. You can't do it in your brain and not put it down. So when Bill Worski jumps up, Judge, both sides agreed to this. We drafted a proposal. We drafted an order that had all the findings. It just hadn't gotten signed yet. Like, Bill, sit down. Mr. Worski, sit down. Judge, like, not part of the record. And that is, they're going to be an issue. This is a very, very, very good argument that they can make. And of course, the defense is going to have arguments back on their side, right? They're going to argue that the defense didn't object to this at trial. Judge, they didn't object to it. It's not timely raised because they went along with this at trial. The defense in their motion tried to combat that and say that Mike Howard wasn't aware of the restrictions. And that's where Mr. Stoller comes into place, and if you paid attention to the first trial, he was the public information officer, and he has been subpoenaed to come and testify tomorrow because he is the person that then took the judge's order, placing his restrictions. He is the one who administered that order. So he actually is the one that emailed out to people and said you got 15 seats for the family and Metcalfs and 15 seats for Karmelo Anthony. Although Karmelo Anthony's family didn't get the full 15 seats, I think they only got like 8. So his grandmother wasn't able to be in the trial daily. And so that left, they decide, he is the one that decided the 27 people from the public that come in and how that was going to be managed. He also decided what legacy media was going to be decided, so he's very integral in making that decision and administering the judge's restrictions. So he has been subpoenaed to come and testify about that tomorrow. So we'll get to hear, but that is the big argument. And the law says that if these things were violated, if Waller and Presley were not followed, if those requirements that the judge has to consider were not done, then Karmelo gets a new trial, period. Now, it's not anything in between, he gets a new trial. So that is what is driving a lot of excitement for tomorrow because people don't feel like the first trial was fair. So I'm not, getting into all of what happened under the tent, all of that. That's not going to come out tomorrow. It's going to be legal arguments. So that's their first legal argument. And go to the comments to see if y'all have any questions. Let's see. Okay, I got the super chats. Oh, Khadijah's 2748. Thank you so much. I never even thought about doing that, but I don't know. Maybe I might have to look into that. Let's see. Shout out to the mods in the chat. Thank you all so much for being here. Is it possible Mike Howard could be so naive? I don't think it was naivete. I think what it was they all know each other. These attorneys know each other for a very long time. They were very comfortable with each other. Allegedly, I'm saying this because I don't know for a fact, but I believe Bill Worski and Toby Shook used to work together like in a law office or something like that. It was not any conflict, right? There was no issue about that. Like the legal community is small, just like the doctor community is small. Doctors know each other. There's no conflict for attorneys to know each other. I have friends who are DAs. I have friends who are judges. We'll go out, we hang out. But guess what? When I walk in that courtroom, it's Kevin Gates all day, okay? Straight up, I'm here for my client. So never would I have made a gentleman's agreement in a murder case to try the case clean. And that is the defense's second argument in this motion for new trial. So I was answering a question and then I'm going on. So let me pause. Let me go back to the questions. Kia Elder 305, that's so sweet. She says support our hostess on Cash App if you're enjoying and learning from her knowledge, and gives the Cash App. I appreciate you all. So supportive. Chicken Chow Main 77 is back. You are here every time we have a live. Jersey Girl Trey, shout out.
There's rewarding, and then there's remarkably rewarding with Chase Sapphire Reserve, like enjoying a $500 credit towards our collection of the world's best hotels, and a $300 dining credit to the most coveted tables.
University of Phoenix is built for real life. Some schools say affordable tuition, but their tuition can increase every year. We do it differently. Get locked-in tuition from start to finish of your program and know your tuition costs.
Live Jersey Girl Trey, shout out. Another mod in the house. Thank you so much. Shamina 1908 says they need to check the cases the judge presided over. Yeah, they're not going to go through all of that. When they get a motion to recuse, this is just going to be focused on this case because it's basically related to his actions only in this case. There haven't been any other issues raised. I don't think he's given any interviews in any other cases. Shout out to Khadijah 2748 since 10 jewels. Thank you so much, sis. You've been so supportive of this live. I need to add you to the banner as well. Happily Angry Lawyers back in the house. Thank you. That is the partner that I'm working with. He's out in California. You all follow him on YouTube as well. He is doing some coverage on the Dirt case. Are you going in person tomorrow? I think that case starts tomorrow. So let me know if you're going in person. I'm going to have to check out your live on that. Let's see. Yes, no need to hold a trial in secret. Chicken Chow Main 77 says, with all these off-the-record gentlemen's agreement with no court reporter present, that leads me to believe they were trying to hide things they knew was filed. It just gives like back door, back room, like, you know, I don't know. Yeah, somebody said, can I share your video on YouTube? Yes, please share. Like, share, and subscribe. I don't know. I'm gonna stop saying I don't know. I don't know what the hell was going on in this case. It was a lot of stuff. I was very surprised. Even when I started covering this case, when the verdict came down and we were talking about the defense, why isn't the defense? Hey, Dr. Cheryl, shout out. Thank you for tuning in. Why isn't the defense, presenting a defense, right? Where is it? And it was because of this gentleman's agreement. So that is prong number 2 of the motion for new trial that will be heard tomorrow. So the trial, this incident happens April 2025. Karmelo Anthony hires attorneys. I think it was like July-ish. I think Mike Howard might have come on the case around September-ish, I think. So from that time all the way until the trial, he's prepping for the trial. The defense was always, this was self-defense. So he's digging up information on the victim, Austin. He's digging up information on Hunter. There, right? We heard rumors about them being bullies. We heard rumors about, well, we didn't hear about this prior arrest, but it comes to find out that stated in Mike Howard's affidavit, so this is alleged, I haven't seen a warrant, but that the kid boys were arrested, Austin and Hunter, for tagging racist graffiti. So they dug up all this information. He had a psychologist that was going to come in and testify about Karmelo's flight response in reference to him having epilepsy and or seizures or whatever that medical condition. I think it was seizures, or it might have been epilepsy, but he had all these people lined up to talk. And some point in like end of April, 1st of May, Toby Shook gets a phone call from Bill Worski offering up this gentleman's agreement. And it's just, we don't have a call, but it's probably just like, hey, Toby, yeah, so we got this trial coming up, and we got bad stuff on both sides. Our victim ain't perfect, and your boy ain't perfect either. So how about we just focus on what happened under the tent? Let's just try this case clean. That was the gentleman's agreement. Let's just try it clean. We'll keep out this 75-page of extrinsic evidence we got on Karmelo, and y'all keep out all that stuff you got on Austin and Hunter, and that doctor coming about the epilepsy. Keep all that out. Let's just let every witness that testified that saw what happened at the track that day under the tent, let's let them just come in and testify, and we'll just let the jury decide based on that. Toby hangs up the phone, has a conversation with Mike Howard. They feel like it's a good deal. So they call each other back, they talk about it, and they think they had about 4 or 5 conversations, and this is per Mike Howard's affidavit, sworn affidavit, and they developed this gentleman's agreement that, hey, handshake, we're going to try this case clean. This gentleman's agreement was never reduced to writing. Judge Roach was aware of the agreement because they discussed it in chambers in front of him. The entire case was tried under this agreement until that Saturday when in the hallway, Mike Howard asks Bill Worski, how many more witnesses you got? And he tells him we should be done around lunch. He says, oh, you're making me possibly have to call my defendant out of order because some of my witnesses aren't available today. And things went ham. So Bill Worski says the agreement Mike Howard's word. So we haven't heard Bill Worski speak on this, but we'll hear tomorrow. Mike Howard says, Karmelo's going to be, I have to move up his testimony. And Bill Worski says, wait a minute, we never covered Karmelo testifying. So if you put him up, we're bringing in all of this 75-page. That is BS, okay? Because how else were they going to get in this extrinsic evidence on Karmelo if not through Karmelo? So what was the reason Mike Howard and Toby Shook would even enter the agreement if not for their client to be able to testify freely? Like, that is the most ridiculous thing for them to say Karmelo wasn't covered. And so when that sounded ridiculous, they say, well, you opened the door when you mentioned that he played chess in your opening.
Come on, come
Open
on.
multiple cinemas.
When that sounded ridiculous, they say, well, you opened the door when you mentioned that he played chess in your opening. Even more ridiculous. Playing chess is not indicative of anything. People play football and kill people. Playing a sport or chess doesn't mean anything. Like, unprofessional NFL players in jail right now for murder. Like, that doesn't mean, oh, he's got good character because he plays chess. No. So the judge says that didn't break the agreement. He tells the state that. And the state still says the agreement doesn't cover Karmelo. And that's Mike Howard's fault. First off, he should have never entered into this agreement. Secondly, you get it in writing. You protect your client. You get it in writing. You put it on the record. Because remember, this is how they behaved. The entire trial was based off this gentleman's agreement. So they're in the back hallway. It got heated. Mike Howard says that they were in a shouting match. I don't know if you all were watching the trial, but on, I believe, Monday. So this all went down. The conversation starts Saturday, and then, the state rested and the defense started, but they were going to have to, so come Monday, there's this pause for like 2 hours in the case. I believe it was on Monday. And everybody's like, what's going on? Judge said be back at this time for lunch, and we're still sitting outside. What's going on? It's this argument. It's this blowing up. So now, they're like, oh, got to put Karmelo up. And they're like, well, we're bringing in that extrinsic evidence against him if he testifies. So they get the judge involved. Judge, you already know about the agreement. We've tried this entire case based off this agreement. How are they able to renege now? And the judge is like, well, I am aware of the agreement, but I think the state is, I have to follow the law in this case. So if Karmelo testifies and the state crosses him and tries to bring in something, I got to follow the law on this, and I'm going to have to allow that evidence in if he testifies, because there's no way he can testify and not open the door to that extrinsic evidence. Whatever that extrinsic evidence was, it was not filed as part of the affidavit, so I don't know if we'll find out tomorrow. I don't know if it's ever come out what it is, but guess what? There's never... I don't know if you don't get to just bring in extrinsic evidence, right? So if someone says like, hey, I got all these similar transactions, you did this same thing before, you killed somebody before, you acted in this manner before, or you did some, you got to fight in school, you brought a weapon to school, you did this, and I want to bring it into this case. You don't get to just do it. You have to have a hearing. And that hearing, there are certain factors that are considered. Is this relevant? Is it more prejudicial than it is relevant? Like, there's considerations that are heard before you decide if that evidence is going to come in. So I don't know. Did they have a pretrial hearing on this evidence? We were like 2 months before the trial, so maybe they did. But guess what? We don't know because it wasn't on the record. All of the pretrial hearings were done in chambers with no court reporter. So I don't know if there was a hearing on this 75 pages of extrinsic evidence or not. But if there wasn't, there's going to be an issue with the judge telling Karmelo that, son, if you testify, you're going to open the door and I'm going to, have to allow all that stuff in. If he never had a hearing on that, how can you tell him that you're going to let that in if he testifies, right? That's also violating his rights, and something that they raised in the argument with this gentleman's agreement. They talk about how, so this gentleman's agreement blows up, the attorneys are back there arguing, the judge tells them to walk it off. They come back, and then they have this argument with the judge, and the judge is like, I'm going to rule based on the evidence, on the law, and I'm going to allow it in if he testifies. So Karmelo and his attorney go to the back. I think his family was brought in. They had 10 minutes to make a decision. That's what the defense says. Now, the state didn't file a response to this motion, but they made public statements and said that Karmelo had 30 minutes. But whatever, that's not the point. The point is how this happened, right? It's this gentleman's agreement that's broken. And so Karmelo's scrambling. So you got to think from the minute this happened until this moment, the defense has always been self-defense. I did this, but it was in self-defense. And now you're snatching away the defendant's ability to be able to testify about this defense because the gentleman's agreement is no good anymore. So that is the issue prong 2 of the motion for new trial. Now, this isn't a structural error. This isn't where if they find this gentleman's agreement was violated, he gets a new trial. No, they're just saying, Judge, we need to have a hearing on. We need to have a hearing so we can put facts on the record about how all this went down. Because guess what? There is no record. There's no record of this gentleman's agreement, so we don't know, anything, any particulars, because there wasn't a court reporter, wasn't taken down. So that's the purpose of this hearing, so that they can flesh all that out, which means Bill Werski will have to testify tomorrow. So the DA will be testifying. That is why on Monday, I believe, the 17th, the defense filed motions to keep the state from being both a witness and an advocate in the case. Like, you gonna come in here tomorrow and you're either gonna be at the state's table and you're gonna argue the whole time, or you're gonna sit in the gallery because you're gonna be on the witness stand testifying about how things happen, but you can't do both. That's why you rarely see the trial attorney bringing an appeals issue, because most times, if we're not being if it's not made an argument of ineffective assistance of counsel against that attorney, then they'll have to testify. They're using him. Mike Howard is helping, right? So it's usually somebody else. And usually an appeals attorney would handle this motion for new trial or whatever. But it seems like Bill Werski and his partner are going to be there tomorrow to handle it. So it's going to be interesting to see what the judge says, because he's going to have to decide that at the beginning before it starts. Is he going to allow Mr. Werski to be advocate, or is he going to have to only be witness? Guess who else can be a witness now that they've been recused? Judge Roach. They've been recused. Judge Roach, you're a witness too. So come on in here with the subpoena tomorrow, because you're no longer the judge on the case. You need to get on witness stand because we have no record. So we get to ask you some questions. So I don't know if he's going to be there, but I definitely would be subpoenaing Judge Roach so that he could be a witness, because you're part of this gentleman's agreement and it forming and everything as well, which is the basis of our argument. So we're having a hearing on it. So buddy, get on the stand. I need you. So let's see. Somebody says Khadijah 2748 says they got played. Yep, they got played. That's why you don't play. That's why you don't trust. Like, we can be cool, we can go hang out, but when it comes to that courtroom, I'm telling you, like, it's no games. I'm fighting for my client. I'm arguing you down. And then once it's over with and I get what I want and my client goes home, then we can go back to kikiing and talking. But we're not cool in here. My duty is to my client at all times. JP Sportsman says every Karmelo supporter is too stupid to understand proportional use of force. I don't agree with that, but I do think that a lot of lay people are confused in this. And, there are issues with this case, right? But we didn't hear everything that get to come out at this trial, because there was this gentleman's agreement. So there's a lot of stuff that we don't know about this case, and we'll get to hear it tomorrow come out. Stephen Jones, on2JM says Mike Howard may have been an actor in this non-gentleman's agreement. He knew better, right? And so the fact that they knew each other and they worked together in the past made them very comfortable with each other and trusting, and maybe that is why everything was so lax. But yeah, so that's prong 2. Number 3, the third part of the argument is the provocation. They're saying that the judge gave the jury a jury instruction on provocation and that it was improper. And so I didn't really understand. Like, I did a live and a video on this argument, so I got the legal argument of it, but I didn't understand like how big this argument was until I saw the transcripts. And I'm going to do a live on it, not tonight, because Fitz started talking, but a live later. So stay tuned to the channel to go over the transcripts, and we're going to break down the opening statement. And as I read it, my mouth, I was like, oh my God, I understand how the jury got here, especially when the defense fell apart. So the state starts out in their opening and they're saying basically like Karmelo brought a knife to the track meet that day with the intention to goad somebody, to provoke somebody to fuck with him, basically, so that he can stab him. And like, how ridiculous is that? Like, does anybody really believe that? But that is the argument. And so they're saying when he sat under the tent, this is their opening, when he sat under the tent and was defiant and ignored the 15 times of being told to leave under the tent and told them, you're some pussies, y'all gonna have to make me leave, touch me and find out what happens, that all of that was trying to get somebody to touch him so that as soon as they touched him, he could stab them in the heart. I mean, although the actions kind of happened that way, I just don't believe that that was his intent. And I think and I don't think the evidence came out that that was his intent, right? There was nobody that testified that they knew Karmelo was going to do or felt like I didn't hear any testimony or see any tweets about the testimony that led to that. So that's what the defense is arguing about. There's no evidence that Karmelo acted with provocation, like this whole provocation thing. And if also, that's what the instruction was saying, that if the jury found that he acted with provocation, that self-defense was out the window. You can't even consider it. So not only did the gentleman's agreement and the falling apart of that mess up the defense, right? He couldn't even testify to even present a full self-defense case. The state was arguing and gave this jury instruction that said, if you believe Karmelo provoked this altercation so he could stab, then he doesn't get to claim self-defense. So I further understand how we're here. Okay, so those things that are things that won't happen again at a trial, and the court says in that case, improper jury instruction is not just harmless error, that also is a structural error. So, you know, there's some big arguments, and then the fourth argument is just the cumulative effect of all of those issues that were mentioned in the motion. Just mean Karmelo didn't get due process, he didn't get a fair trial and deserves a new trial. So I hope whoever had the question earlier about trying to understand why we're having these legal arguments and why it's not based on the facts. This is why. So everything after post-conviction is straight what the law is. Did the judge follow it? Did the attorneys follow it? Were all the laws follow? So it's not about, do we really think you're guilty? Do we really think you're innocent? Do any of that? Is what was the law followed? So I had some super chats and stuff come in. Let me see. TKO every time 19 sends a $2 super chat. Thank you so much for your support. Says great live. I didn't know all this went down. Yes. So I got a whole playlist on YouTube of the Karmelo Anthony case. Been breaking that down. So if you want to go check out any more coverage on it, like we broke everything down on that motion for new trial live. And like I say, I always try to go back and cut it up in videos so people can kind of follow along. Shout out to a super chat a Cash App, $5 Cash App. Thank you so much. I was trying to see if there was a nickname, because sometimes people have nicknames and I always read out your real name. And Kola Wale, I believe that's how you pronounce it. Thank you so much for that $5 Cash App. Thank you. All right, so let me see if there are any questions in the chat. Let's see. Someone, Chicken Chow Main, says placing a defendant under unreasonable duress. And I believe you're talking about the whole 30-minute, 10-minute decision about to testify. Not necessarily duress, but it definitely is.
I don't fit the mold. I never thought about it.
I just do what I...
Decision about to testify. Not necessarily duress, but it definitely is. It doesn't feel right? When you hear that and knowing that for 10 months, 10, 11 months, you've been planning this self-defense. And this is when Karmelo Anthony's parents after say, we just trusted that everything would be okay. What they're saying is like, the attorney told us, we're making this agreement, this is how it's going to be. The attorney didn't know shit was going to blow up, the last day of the trial. And it's shortly after that blow up and Karmelo decided not to testify, the defense rested. So it literally was like, I think they had 5 witnesses testify, and that was it. It was such a sorry defense, and we all were like, what happened? That's what happened. Gentleman's agreement that blew up. And so tomorrow is going to be very interesting. I'm very excited to see the legal arguments. If you haven't gathered now, look, Fit loves the law over here. So I am here flying into town to hear the legal arguments. I am waiting and excited to see how this legal argument is going to go down. I think that is a very strong argument. Not seen the defense's argument because they had not filed a response. They're just going to simply argue tomorrow. So we'll see, how things go. I don't think the judge will have a ruling tomorrow. I think the judge will take it under advisement. What that means is that they'll take it back. They'll do some legal research on it. They could ask the state to brief the issue and then come with a ruling. That's what I think will happen. But we'll see. It could be as soon as the last word. I remember, because I've always wanted to be a lawyer since I was 4. So I went to University of Georgia for undergrad, and I got a speeding ticket. And it actually was my second speeding ticket. The law in Georgia came out 97. I feel like I was the first person to get a ticket.
Okay, I'm going to just go ahead and end this here. I thank y'all for being here, and I hope to see y'all again soon. Good night.